the largest class action settlement in Australian history.
Families are crying for answers and compensation.
Class action?
Let him finish.
Hollywood's showing the power of class actions.
The judge came back with a number.
How ordinary people can take on huge corporations and win.
He's going to make them pay $333 million.
In the real world, it's the lawyers and those investing in class actions earning hundreds of millions of dollars.
No, I really smelt a rat when you'd ask questions and you wouldn't get a straightforward answer.
Some treating their clients with total contempt.
The whole strategy was an attempt to crush my mum.
Profitability has become the prevailing mantra. The transaction costs are high, the legal costs are high, the funding commissions are high, and the ultimate people who pay the price are the class members.
When class actions win, more than half the payout can disappear in legal fees and commissions. And it's often the disadvantaged who suffer the most. Do you know how much they took in fees, Minnie, the lawyers? What's your opinion of it all?
It's woeful. We get the scraps once again.
Without class actions, the victims would get nothing. You're really betting on the class action being successful.
We don't see it as gambling, we see it as investing.
Victims say they're taking too much. In the past 2 decades, litigation funders have earned $1 billion.
We are being used over and over again to make money for other people. How are these people sleeping at night?
In this episode of Four Corners, we ask, are class actions delivering justice for ordinary Australians? Or have they simply become a money-making exercise? We reveal how those who fund class actions are making massive profits, while law firms pocket huge fees, leaving people they represent feeling exploited all over again. In the gold rush town of Ballarat, many retirees had their savings in a little-known investment firm, Banksia Securities. 89-year-old former bus driver and plane spotter Keith Pittman was one of them.
Well, there's 1,400 odd around Ballarat, 16,000 statewide, and the largest number of retirees. And I'd imagine now there's probably a third to probably close to half have passed away.
When Banksia collapsed in 2012, many of those retirees were left with nothing.
Well, Banksia went down to the tune of 660 million. We'd lost a few dollars. Some people had hundreds of thousands and so forth, and some of it was their retirement savings, and they're, just colossal. That's just the law. It takes time.
Takes time, yes. No.
Keith was on a committee working with the receivers to try and claw back the lost money.
I don't fully understand legal work and what's involved, but it would appear the receivers did most of the hard work.
That's when a high-flying lawyer named Mark Elliott and his legal team proposed another solution, a class action.
Well, I thought it was a good idea. Initially, you trust your lawyer. They're supposedly the most trustworthy people in our society.
Class actions are expensive to run. That's why there are companies called litigation funders that invest in them. In return, they take a commission from any payout. In the Banksia case, the class action lawyers were also the litigation funders.
I didn't know what the lawyers were charging it. I had no idea. That only came out later.
Like most of the group, Keith didn't know all the details. The only person consulted throughout a class action is the lead plaintiff, someone who represents the group and approves the costs and any payout.
It's embarrassing that you can't pay your bills.
After 5 long years, the lawyers negotiated a $64 million settlement. Of that, they'd take $5.2 million in legal costs and just over $14 million in commission for funding the case. More than $19 million in total, almost a third of the settlement. Virtually everyone agreed to the deal, except Keith Pittman. When you first saw the amount of fees that were going to be taken by the lawyers, what was your reaction?
Oh, shocked. Just exorbitant fees. It just didn't seem right.
The other investors had faith in the class action lawyers, but Keith Pittman didn't trust them.
I really smelt a rat when I asked questions and you wouldn't get a straightforward answer. I'd been on this Banksia committee and I had a feeling things weren't right, so that's why I objected. And there was only 2 of us objected out of 16,000 odd.
Another state away, retired Adelaide nurse Wendy Botsman was also worried.
Very nervous about where it was going to head.
Like most of the retirees, Wendy was out of her depth. Fortunately, she had a lawyer for a son.
This is part of the problem because, by definition, class members are vulnerable. So something bad has happened to a large group of people, and they don't necessarily have any background in the law.
Chris Botsman came to the same conclusion as Keith.
The amount of money that the class action was seeking to claim in terms of fees and commission looked high.
I came home to find...
Wendy and Keith both objected, but the class action settlement was still approved as fair and reasonable by the court. Their only option was to lodge an appeal. That's when the class action lawyers began a campaign of intimidation.
Where to start? They wanted to serve papers to me, and then there was the letter from the solicitor saying that, you know, I could end up losing my house if I went ahead with it.
And how did that make you feel?
Frightened.
And we're piecing together the story. But it was horrendous for Mum because she was fearful that the total exposure that she faced if we were unsuccessful would be financially crippling.
The only sad thing is I thought we would be looked after. But, you know, lawyers go in to fight for you.
When the appeal finally made it to court, an elaborate fraud began unravelling.
Orders were made for their legal team to produce documents, and one solution that they came up with was to fabricate documents.
The court found the lawyers had fraudulently backdated invoices to gouge costs out of the settlement. Mark Elliott and another lawyer were exposed as masterminds of a dishonest and fraudulent scheme.
They placed paid stamps on invoices. They tried to create the impression of having done a lot of work. These people were involved in class actions for personal enrichment. They're so close to getting away with a $20 million heist.
On October 11, 2021, Victoria's Supreme Court handed down its findings. The court was scathing, saying the attempt to claim more than $19 million in fees and commissions from a group of elderly investors was dishonourable and fraudulent. The judge described it as one of the darkest chapters in Victoria's legal history. As the shocking details were laid bare, lawyer Mark Elliott took his own life. Months later, an expert who'd signed off on the legal costs also died by suicide. He wasn't accused of any wrongdoing.
He was put in the horrible position that he was put in by the greed and entitlement of Mark Elliott. There were days when I felt like throwing up. There were days when I felt as though my chest was being squeezed in a vice.
In the wake of the fraud, 3 other lawyers were struck off. The Banksia scandal would never have been discovered except for a lawyer and 2 determined retirees.
Well, I felt obligated to get a better deal, particularly for the World War II veterans that put their life on the line for our country, and these rotters have ripped them off. That's what really gets under my craw.
Do you think without Chris you would have been able to pursue this?
No way. No.
The Banksia case shows the power imbalance between sophisticated class action players and their often vulnerable clients.
I think that the only reason that it was exposed was a coincidence, and the coincidence was that one of the class members, my mother, happened to have a lawyer as a son, and a lawyer as a son who had experience in class actions.
Thousands of survivors of the deadliest Black Saturday bushfire have won nearly $500 million in compensation.
From natural disasters to corporate scandals.
Today there is an element of relief.
For victims, joining a class action is often their only chance of compensation and justice.
We've had to sue our own government to get the justice that we deserve.
The return to each claimant will vary, and about 12% will go towards lawyers' costs.
But some say they've become a money-making machine.
This case has gone on far too long. It's been far too expensive, and it's had...
Peter Cashman was the king of class actions in the 90s, when most lawyers took cases on a no-win, no-fee basis. Everything changed, he says, when a High Court decision 19 years ago allowed litigation funders to invest in class actions. Most people think class actions are initiated by a group of victims. That's not the case anymore, is it?
It's very rare that the case will be initiated by someone simply because they have a grievance. Quite often they're orchestrated by a combination of commercial funders and law firms. They will often identify a potential claim and proactively seek out people who might be potential class members and then hopefully sign them up.
If a class action leads to a settlement and the judge approves it, the lawyers and funder receive a large slice of the payout.
The transaction costs are high, the legal costs are high, the funding commissions are high, and the ultimate people who pay the price are the consumers or the class members who get substantially reduced settlements. That's out of kilter with what's happening elsewhere in the world and would simply not be permitted.
Litigation funders aren't regulated in Australia. That's meant overseas players, including those based in tax havens, have flooded the market. They can get 2 to 3 times their investment back, sometimes more.
Australia has become a honeypot for commercial investors in litigation. They're not in it for love, and they're not in it to further the interests of access to justice.
They're in it for the money.
They're in it for the money. Unfortunately, profitability has become the prevailing mantra.
I'm a farmer's son. I come at this from a social justice bent. We're a for-profit industry and we seek to maximise profit as much as we can, but at the same time seek to focus on creating value.
John Walker pioneered litigation funding in Australia. He co-founded one of the world's largest funders, now worth more than $400 million.
I'm absolutely proud of what's happened with class actions in Australia. They're absolutely essential to create accountability in respect of the big companies and governments.
He says legal costs are too high for the average person, and that's where funders step in.
We underwrite the project. We'll pay everybody if we lose, but in return, if we win, then we get a share of the recovery.
You're really betting on the class action being successful.
We don't see it as gambling, we see it as investing. It's a market, and I don't step away from that.
When a litigation funder invests in a class action, the victims, on average, get less than 60% of the payout, and in some cases, less than half. If they're getting 50% or less of the settlement, is that fair?
I don't think it's a success. Fairness is a big part of it, but it's not just the money, it's also making the behaviour accountable. Now, class actions do two things. One is seek compensation, and the other is to create a deterrent, to show that Big End is going to be accountable for its behaviour.
Class actions are now so common, there's at least one launched every week on average. Leading law firm Morris Blackburn signed up thousands of taxi drivers after Uber decimated their business. So just how bad was it for you guys when Uber entered the market?
Oh, it was devastating. People virtually went into shock.
Queensland taxi owner Stephen Lacars says his licence, once valued at $500,000, is now virtually worthless. He says drivers now need to work around the clock to make a living.
Young guys that had bought in and that were up to their neck in debt, they never saw their family.
Morris Blackburn lawyers. We fight for fair.
When Morris Blackburn proposed a class action, Stephen Lacars was quick to sign up.
And they arranged a couple of information sessions. Morris Blackburn sent up a couple of personnel, very professional, very inspiring. And we were friendless. And here comes Morris Blackburn with their Bradman-like batting averages and their We Fight for Fair banner, and we're there with bells on.
The case was bankrolled by an offshore firm, Harbour Litigation Funding, registered in the Cayman Islands tax haven. They'd take 30% of the proceeds. Stephen says he agreed to this, hoping the likely payout would be in the billions. So therefore, if you were going to lose 30% of billions of dollars of payout, it didn't seem such a big price to pay.
No.
The night before the trial was due to start in March last year, Morris Blackburn brokered a deal.
Uber will pay $272 million in a settlement to compensate taxi and hire car drivers.
Stephen saw it as a slap in the face.
We were never consulted. Is this okay? This is about how much you'll get. Is that a fair enough deal? If I had mounted this legal action on my own, one-to-one with a law firm, I cannot believe that they would, without very, very specific instructions from me, enter into a binding settlement with the defendant.
The reality is, only the lead plaintiff needs to be consulted about a proposed settlement. From the almost $272 million settlement, Harbour received an $81.5 million commission, a more than 250% return on their investment. Maurice Blackburn received almost $39 million in legal costs. That left thousands of drivers with just over half the payout. And so how much do you expect to get of the payout?
The projection is something like $43,000 minus the legal fees and funding fees. So just a little bit more than half of that.
A little bit more than 20,000?
Yep.
It was not anywhere near what you expected?
No. They've thrown a few dollars at it and looks like they've got what they need, and that's what matters.
Stephen never got to see how Maurice Blackburn's $39 million legal bill was calculated. The firm kept those details hidden from the public under a court order and ignored our request to see the report.
It's funny because there's lots of things that were hidden behind the cloak of confidentiality, and some things apparently more confidential than others. The costs of Maurice Blackburn are supposedly very confidential.
Maurice Blackburn wouldn't do an interview with Four Corners. The firm said the settlement was assessed as fair and reasonable and approved by the Supreme Court of Victoria. It was the 5th highest class action settlement in Australian history, and around 98% of the members signed an agreement with the litigation funder. Harbour Litigation Funding told us the case was long-running, hard-fought and complex, and that group members were told about the commission. Basically, John Walker wasn't involved in the Uber case. He was prepared to go on camera on behalf of litigation funders. The taxi drivers in the Uber class action got just over half the settlement of $272 million. Is that fair?
The same question, is that fair? Look, I don't think it's fair that in circumstances where there has been identified bad behaviour and where it's breached our norms, we've tried to do the best we can to achieve 100% recovery for losses caused by that bad behaviour.
In Canberra, there's been a battle over class action law firms and litigation funders.
We have a system where litigation funders who are taking sometimes 30, 40% of the settlement away from victims operate in a largely unregulated environment. In many instances, you could argue that they have less regulation than real estate agents or mortgage brokers.
The Morrison government tried to crack down on lawyers and funders by capping their fees and commissions at 30% of the settlement and forcing funders to be licensed by ASIC. Labor was opposed.
So the legislative proposals never ultimately went through the Parliament because of the Labor opposition, but there are no rules or regulations in place at the moment.
Why would Labor oppose reforms that meant that group members would get 70% of any settlement?
We know historically that the Labor Party has had strong links with what we call these plaintiff law firms. So think of the Slater and Gordons and the Maurice Blackburns. They're often seen as a training ground for future Labor politicians, the likes of Julia Gillard and others, but they're also financial backers for the Australian Labor Party. Clearly, Labor was lobbied by these plaintiff law firms. Labor was sympathetic to the cause of these plaintiff law firms. But ultimately, these plaintiff law firms just knew that their profit share was at risk if these reforms went through.
Maurice Blackburn said it actively engaged with decision makers to make sure everyday Australians were better represented by the law. The Attorney General's office told us that class actions provide an important pathway for Australians who might otherwise be denied justice.
Litigation funding agreement.
John Walker says the Coalition and the Liberal Party-aligned Menzies Research Centre have their own agenda.
You know, Coalition to a large extent wants, and through the Menzies Research Centre, does want to look after the big end of town.
Absolutely not. We actually haven't received, to the best of my knowledge, any money from any business that's currently facing a class action. We now operate in a system where there is very little regulation, transparency and oversight for litigation funders.
Since there's not any real regulation of the litigation funders, is there any other investment class which makes such big profits that isn't regulated?
Big profits, no regulation. So they're the basis for your question. I disagree with both. First, we are regulated daily. The system has a capacity to do the best it can. It has checks and balances. The first one is for claimants. They have a capacity, and the court is open to hear from each and every one of them and have their day in court. We are regulated every day on a bespoke basis. We need to submit to the court and say, you tell us what we're going to get paid. And in my view, it's wrong to say we're not regulated. And I also say and believe that we aren't overpaid.
Aboriginal men, women and children who worked for little or no pay, many cases were tantamount to slavery.
It's one of the most wretched and little-known chapters in the nation's history.
The state expects us to civilise these people. That's the philosophy.
Thousands of Aboriginal men, women and children forced to work on missions and outback stations for little or nothing.
They all got sick and tired of this getting pushed around a lot.
After successive governments largely ignored this shameful treatment, Australia's largest litigation funder saw an opportunity. Litigation Lending Services enlisted Shine lawyers and launched class actions in WA and the Northern Territory. They began signing up Indigenous workers and their descendants who were exploited from the 1930s to the early 70s. We've been trying to find Minnie McDonald. She's the woman that Shine signed up as its lead plaintiff in the Northern Territory stolen wages class action. Now, Minnie's in her 90s and she's never spoken publicly. In fact, all we've had is a photograph that Shine provided. But after we applied for some court documents, we found a number for Minnie. So we gave her a call and she's agreed to talk to us.
But that's all right. We got it.
Minnie started working at Lake Nash Station near the Queensland border at age 14.
Anybody knock knock?
Her family was paid in rations.
Well, they used to help us a little bit, taka, sugar, flour, rice. They used to put them in the bag, you know, a little bit. Tea leaf.
Minnie says sometimes the station managers would kill cattle and give her family the leftovers.
They kill a bullock for themselves, you know, get meat, everything, station, and bring a bone for all the people in the camp.
Oh, you would just get the bones?
Yeah. And bullock food, everything. We had to cook them anyway. My mother used to cook it. Bone, backbone, leg bone, everything, you know. Everybody come up, share it out, you know, for workers any old way. Yeah. That was early days, long time ago, you know.
As the lead plaintiff, Minnie had a crucial role in reviewing and signing legal documents for the class action. But Minnie can't read or write.
And did they know that you're not able to read?
Everybody know, yeah.
But the Shine lawyer mob.
Yeah, I told him right there.
Her granddaughter Elizabeth helped Minnie make sense of all the paperwork.
So when you had to read all of those documents, who was doing that for you?
Myself and the lawyer. The lawyer sort of broke it down a bit and then I translated and tell Minnie what it was all about. Yeah.
Minnie signed one document that proposed an almost $11 million increase to Shine's costs.
When I was growing up, and I used to work on the station, I was too young to get paid.
Thank you.
Can I go like this?
Yeah.
The lead plaintiff in the WA class action was Mervyn Street. He can't read or write either. When asked about Minnie and Mervyn's capacity to understand legal and financial issues, Shine said it used Aboriginal barristers to bridge communication and cultural barriers. Shine said both received independent legal advice. Shine travelled to more than 100 Indigenous communities in WA and the NT to sign people up to the stolen wages cases.
Are they the litigators?
Oh, no. Traditional owners from the resource-rich Pilbara, Sharon Todd, her sister Jenny Baraga and cousin George Dan, joined the class action with thousands of others.
I just thought it was great that our mob, like my dad and my mum, were finally going to be recognised for the work that they did. That is our mother's mother. She was born in 1900. And it says as they appeared when they first came to Dulles.
Their grandmother was forcibly removed from her home in the 1940s.
Our father used to talk about how that day with her on the rock, they made a spectacle of her.
This photo shows her wearing shackles around her ankles.
She's wearing shackles. Why?
Yes, they shackled her. She was dressed up in this outfit originally, and then they eventually were brought into town, and she was stripped of her clothing after that.
Dad tells this story. They chained her up so the kids wouldn't run away.
There's an area there, it had a big ring on it, and they chained them to that ring.
Some of those kids, and later their children, worked on outback stations. George Dan began working as a teenager.
I started work when I was 13, 14 years old. You know, I worked on the station, £3 a week. You gave you a tin of tobacco, I got a tin of tobacco, and there was my wages for the rest of the week, from sun up to sundown, 7 days a week.
These women from the remote community of Titchikala, south of Alice Springs, all signed up. Artist Nita Ferguson is in her 70s. She began working on cattle stations as a child.
I used to work like rinsing dishes and washing plates and wiping down plates.
What age were you when you started doing that?
I must have been 5 or 6.
At 16, Nita moved to Alice Springs to get a job, but says the station owners brought her back.
I could have come into town and worked for hundreds of dollars. I did work like a slave children.
Did you think that they treated you like slaves?
I think. Yeah. Just nothing else but just work, just run around, do work. I am sad all about all that. After all, we lived in a humpy. No electricity, anything.
Did you think that you were going to get the money that was owed to you after all those years?
I was thinking we'll get about 200 to 100,000 each.
Both class actions were settled over the past 2 years for $180 million in WA and about $200 million in the Northern Territory. Overall, Shine Lawyers will receive at least $41.6 million for its work, while the funder, Litigation Lending Services, will take a commission of up to $57 million. The exact amount that Aboriginal workers will receive is unclear. Based on the court judgments, Four Corners estimates they'll get between $10,000 and $14,000.
You know, it's woeful.
Do you know how much the lawyers in WA are getting as part of the settlement?
I do not know.
The lawyers are getting $27.5 million.
So we get the scraps once again.
It's a real insult. A real insult. It just makes me feel that we are an industry that are being used over and over again to make money for other people. How are these people sleeping at night, you know?
The federal court judge criticised Shine, saying it ran up enormous costs. The firm had 64 law clerks charging at a $375 hourly rate. Many were undergraduate law students. The judge said that they were excessive hourly rates charged by Shine, and the fees were seriously overblown. He shaved $4 million off the legal bill.
I'd like to see them fellas there now get what our family got. They get that in an hour, what our family would get in a year.
It's not good enough.
In the Northern Territory, the Chief Justice went further. She said the pursuit of the business model had at times overshadowed the good intentions of the lawyers. Shine overcharged for some of the work law clerks had done and elected to do some work in the most expensive way. She said some Indigenous workers and their families might view the case as little more than a money-making exercise and doubted they would see much social justice in this outcome. We got hold of this confidential report into Shine's costs for the WA class action. It shows that Shine hired at least a dozen barristers at a total cost of almost $3.5 million, with one charging almost $5,000 an hour. The court accepted those costs, but when Shine tried to claim $35,000 in booking and credit card fees and almost $40,000 in meals, coffee and alcohol, the court knocked them back.
You got me. I was going the wrong way.
There's nothing luxurious about Minnie McDonald's life in Alice Springs. Now in her 90s, Minnie doesn't ask for much, but neither she nor her granddaughter believe a $10,000 to $14,000 payout is fair.
I reckon it's not enough, really, to say, you know, for the old people that actually worked back in the days, you know. They had a hard life.
What do you think, Minnie?
That's true, yeah. I know. I've been go through that, you know. Yeah. No shoes, get up in the morning, go to work. Come back afternoon cold. I would think give me a little bit more. Kid might get car and just take me for picnic somewhere, you know, have a feed, cook kangaroo tail or whatever. Yeah.
You didn't get enough to buy a car?
Yeah, nothing, not enough.
During our interview, Minnie's phone is constantly ringing.
Hey, stop ringing there, your mouth. Hey? Wait, yeah.
What are they ringing you about?
Oh, what's happening, when we're going to get the money and everything, you know?
Shine Lawyers didn't want to do an interview. Shine said in a statement it gave Aboriginal workers the chance to tell their stories, receive compensation and be acknowledged for the historical injustices they suffered. The firm said these cases required experienced and well-resourced lawyers. While acknowledging the criticism it faced, Shine said it was the only law firm willing to take on this challenge and see that workers received a portion of the money owed to them. The funder of the stolen wages cases, Litigation Lending Services, bankrolled another action in Queensland. They're set to make up to $95 million in commission from all three cases, a 250% return on their investment.
Is that appropriate, do you think?
It gets back to, is it appropriate for what the Australian government and the Australians did to the community? And what we're trying to work out is what is the best way to resolve disputes.
But in that circumstance, couldn't Litigation Lending Services have taken a smaller commission?
It depends on, I don't know, on their personal commercial circumstances, whether they'd lost money on others or whether they... I just don't know the circumstance. It's a market trying to work out a social solution that isn't always perfect, but we do the best we can, but we can do better.
But if it does hold itself up as saying we are running this social justice campaign and they take great pride in it, yet make an absolute fortune, why don't they just take less?
What's your answer to that?
Well, aren't they being...
You're saying they shouldn't have. The courts are now the ones that are the only ones that decide what is fair. In asking the question, you're really asking whether the judge got it right. And I don't know whether you know enough about it to ask that question.
Litigation Lending Services said without their financial support and commitment, group members would have received nothing. They told us they remain proud of their role and deliberately set their commission below market rates to reflect the social justice nature of the claims.
If litigation funders and the plaintiff lawyers are in there saying, we're here for social justice causes, but in reality, aren't you as big a company and corporation as those that you're up against?
No. No. Well, no. We're not.
You're making, you're making a lot of money.
Almost invariably, the defendant, in a broad sense, has more money to allocate to the dispute than on the plaintiff's side.
But in reality, you've got a lot more money than the class members, right?
Absolutely, but that's what they need us for. That's our job. I mean, we're trying to bring the money, as much money as we can, certainly enough to be able to try and get some justice.
Litigation funders and class action lawyers say they're the only ones making sure victims get something. But what happens when that something is nowhere near real compensation?
Maurice Blackburn came along and said, we will fight this to get a fair outcome. We're talking cents in the dollar. How can that possibly be fair?
You have a three-way tug of war at the end of the day between the funders, the lawyers and the class members. The lawyers have an interest in maximising their billable time. The funders have an understandable interest in maximising their commercial return, and often the class members are not adequately represented in that process. They don't often have sufficient insight into the issues involved or the complexities of the settlement agreement.
Ultimately, it's the judges who decide what's fair and reasonable. But is that burden too great when they're the only ones regulating the system?
Judges play an important role in controlling both the legal costs and the funding commissions, but it's far too little, far too late. It's at the end of the day when the costs have been incurred. Most judges don't want to second-guess the forensic decisions that were made during the course of the case.
All of us as Australians are diminished, while the Aborigines are denied their rightful place in this nation.
If ever there was a need for justice, it's for those First Nations workers who were so shockingly exploited. After almost a year in WA, they're still waiting for their share, while the lawyers have already been paid.
It's a farce, like everybody's saying, you know. It really is. They say people are going to get 184 million. That's what they stated, didn't they? But it's not. They're all a big mob of liars. They should be the ones to put up what our people put up with. You know, a lot of people, they worked all their life. And for this to happen, it's a terrible thing.
If this program has raised concerns for you, you can contact one of these services.